Excuse me.
Yes, yes, ma'am.
Can I follow that order? Because I would be also representing those persons against whom.
You're Mr. Pratik there? All right.
I prepared a short note. Well, my endeavor, since I have also lost the job because of this judgment, my endeavor before your lordship shall be to show the gross incorrectness in the judgment itself.
Yes.
Lord, first, lordship may kindly see the very basis of this judgment, which is challenged before your lordship, was the November's order passed by this honorable court. In the order, my lord, there are 7 fundamental directions which were required to be gone into and followed by the honorable division bench. Lordship, kindly take the first. I have just jotted down that. Now, the first point was, Lordship may kindly put a difference between two situations. Usually, my lord, whenever the matter is heard by your lordships, send the matter, then there is an expectation that the matter will be decided on merit. But there are only few cases when your lordships feel that not only the merit is to be decided, no matter it was pending for last 3 years, 4 years, etc., but also the point of maintainability is to be decided, then my lord, my respectful submission would be that there should not be any prejudice as long as this order stands. So the first part of the order was, though there has been detailed documents, all points, this honorable court felt for whatever reason that there is a necessity to first decide the maintainability of the writ petition itself. The second was to examine the admissibility of the OMR sheet images. Third was, in November 23, when all the documents, affidavits by the CBI and School Service Commissions, everyone was before your lordships, there was an observation in paragraph 8. At this stage, no such outstanding case, because Justice Gangopadhyay passed an order for termination of the large number of teachers. So this was the observation by your lordships. Fourth was, these allegations would have to be established through evidence. Well, I would correlate on this score how the Honorable Division Bench have completely gone incorrectly. Fifth was, well, this is important, to ignore the findings of the earlier Division Bench on Rule 17 plus to decide afresh. Lordship may kindly connect this with the point of maintainability. Because the situation at that point of time, my lord, before this honorable court was that the Honorable Justice Gangopadhyay directed the School Service Commission that you must invoke your power under Rule 17. My lord, School Service Commission is a recommending authority which is governed under a particular rule, for the time being 2016 rule. Once someone is appointed on the basis of a recommendation, as an employee, I am governed under 2018 rules, which is a separate rules altogether. A point was taken before the High Court, before the Honorable Justice Gangopadhyay, and also before the then Division Bench, that once the recommending authority recommends and thereafter an appointment is done, the recommending authority becomes functus officio. But there was a direction by the Justice Gangopadhyay to the recommending authority that you invoke Rule 19, Rule 17, by which you terminate all the ballot, whoever at that point of time the court found that their appointments were illegal, invoking Rule 17. So that point, whether that would be done or not, that was required to be decided, that your lordships held. Now last one, and the next page, CBI to complete investigation and submit its report. Well, this is very important. Lordship may kindly see that after this order, this was a November 23 order. after this order, well, what is usual and what is expected is that the CBI will file a report before the Honorable High Court saying everything, whatever they have got to say. But there are 3 reports which were filed by the CBI. First report was of dated 9th of January 24. That does not contain anything of 65P, anything of scan take, anything of whatever is found to be fundamental today before your lordships. Nothing. Absolute absence. Thereafter, after 19 days, second report was filed by the CBI, 16th of January 24. Lordship may be surprised to take note, in the entire report, there is not even a single word on scan take. I have seen that on the very first day when this matter was moved, one of the basic points that was expressed by your lordship, that how there can be somebody who was not even getting the tender, that's a scan take. So that's an important issue. So after 19 days in the report for the first time, my lord, first 9th of January, nothing. Not even the 65B certificate. Despite November order, there is a requirement to prove it admissibility. 16th of January, no whisper, no word, no sentence, no document on scan take. Last report, 5th of February 24. Now, Lordship may kindly look at 2 fundamental, according to my understanding, flaw. My Lord, after the amendment of the Evidence Act of Section 59, if a particular record happens to be electronic record, the only way of that electronic record to become an evidence is 65B and 65B alone, as held by your lordships in Anwar judgment. Now, there are 2 sets of electronic records as per the last report of the CBI. One Scantic, one Pankaj Bansal. Lordship may kindly have a look at, my lord, I am referring to the state SLP for the convenience, page 768. Lordship has got. Lordship may kindly have a look at this. This is signed by authorized signatory Sri Pankaj Bansal, data analyst, Messrs ND Infosystems Private Limited. But I could have understood. My Lord, if I can give an
So
example.
what's the drift of your argument? We're not able to get-
May I just say and then?
Yes.
I was just thinking of a situation, my Lord, as a counsel. Now, if I sign here, I am signing in the capacity of, my Lord, as a counsel, as an advocate. When I go to my son's school, when I sign there, that signature is not, my Lord, in the capacity of a counsel. As a parent, I am signing. I do not say that Pankaj Bansal could not have signed in the capacity of an ex-employee of NISA. I don't say so. I say that this is having not done so. Can you have a look at Mallet? Who has signed it? Signed, I read it out. Authorized signatory Sri Pankaj Bansal, data analyst, Messrs. ND Info System Private Limited. Mallet, this document is absolutely nothing.
There is an absence of data. That's the whole point.
That would have come. It's not correct. That's not correct. First, what I submit before your lordship is this. In November 23, this Honorable Court wanted the High Court that look at the 7 points, decide the writ petition, including the point of maintainability. If you have to issue any order on the OMR, first decide the admissibility of this OMR sheets as my lord seized by the CBI. Now, what I, my lord, submit before your lordship is this. Your lordships have categorically held that it is 65B certificate and certificate alone. Well, I shall be showing that specific paragraph, not the affidavit, must disclose what is required in the 65B. Now, that will come only after someone, my lord, who is relevant with the organization, he is, my lord, giving a certificate. Today, I could have understood a certificate is given by the Scantech. I would have understood a certificate is given by any employee of the NISA. But this certificate is by X, Y. So this has got absolute a zero value as far as the evidence part is concerned. Now, lordship may kindly take, my lord, the last but one page of my note. Lordship may kindly take, my lord, the Anva judgment, my lord, in the compilations I have given.
We'll see that later. We'll see that judgment later.
My lord, that paragraph 14, if I can read it out by the relevant portion. Any documentary evidence by way of an electronic record under the Evidence Act in view of section 59 and 65A can be proved only in accordance with the procedure prescribed under 65B. So that's the only way out. Now thereafter, I'm skipping few portions. 14, last 2 lines, which is called as a computer depends on the satisfactions of the 4 conditions under 65B2. Now, lordship, kindly take last part 1 page of myself. What, if I can use the word, the blunder the CBI has done? My lord, they have stated in the certificate, I have the exclusive possession of custody of the records. What is required under 65B2A is a lawful control, not the exclusive custody. There is no word, because I can take on the face value that yes, he is saying I am in the lawful control, that is fine. But there has to be words like lawful control, that's a requirement of 65B2A. Instead of the word lawful control, the word that's there, having exclusive custody. Well, this is the first. Second, there has to be a specific statement in the certificate, my lord, that it is regularly fed plus ordinary course of activity, that is 65B to B, completely absent. My third requirement was computer was operating properly, 65B 2C, absent. Last was information equals to reproduction of what was fed in computer in ordinary course of activity, 65B 2D. So therefore, the four requirements under 65B absent in the certificate given by Pankaj, who is not even of NISA. One. Other thing is the Scantech, which in the last report of the CBI has said that he has also done better scanning. There is not even any valid certificate by the Scantech. Now, in this context, now Lordship may kindly come paragraph 335, for which we have lost our job. 330. That's the 17 reasons. Well, I just forgot to indicate one more reason. In the last report regarding the data of the Scantech, Lordship may take note of the fact that what the CBI said in their report, that they seized some data in the form of .dat. Well, in the protocol for any malware scanning, the data has to be in the JPEG or the TTF file. That's the protocol. But it can always be converted to .dat, but that requires another software. The reason for this submission is that technological aspects, a little tweak can make a huge impact. That's the requirement of 65B very stringently. So,
Well, we'll hear them on the 65B.
yes.
Let's hear
Anything
else?
Yes, 335, the first reason that we lost our job, that SSC has appointed the agency, namely NISA, for the purpose of scanning and evaluating OMSs by a closed door. Lordship may kindly consider this. For last 7 years we are serving. I don't have really information, but my instruction is that many competitive examinations, because of the reason that the candidates do not get to know who would be doing the AMR, it is done in the closed door. But I don't have the data. That's the instructions I have got from my clients. Now, High Court could have at least made an attempt to see, is it an unique thing which is done by the School Service Commission in West Bengal, or in all other competitive examinations, the closed door is the common phenomena, because so that the candidates do not get to know this. The second one was why the data Scantech was there. Lordship must. My lord, the
Mr. Dar, now let's hear some other people also.
just 2 minutes.
Yes.
My lord, the rule 2016 rule, Lordship may kindly have a look, rule 21. But I don't say that it's a very proper rule. It should have been better. But the rule requires that this has to be destroyed.
But the scanned mirror images have to be preserved.
That is not in the rule. That's not in the rule. That's, my lord, the common sense I can say. I can say, yes, it's a good thing, it's a transparent. But to say that the rule requires that mirror image should have been there, but that's the findings of the division. That is incorrect. Lordship may kindly have a look at the rule.
There's no requirement of
No,
maintaining a mirror
no
image.
requirement. No requirement. And my lord,
The RTI Act. Which people cannot really supersede the parliamentary step of RTI.
well, may I hand over the, my lord, this 16 rule? And Lordship will not find a single sentence. 24,000 persons have lost their job. But among 149, my lord, as I am representing, there is one wish. But I do say, as a responsible counsel, I do say, my lord, this rule is not proper. That Lordships always come across. It is definitely not proper. But at the same time, as long as the rule is there,
But is it, according to, is it possible to segregate those who are tainted from those who are not tainted?
well, there are two ways of looking at it. One, Lordship is assuming that some people are tainted because.
According to you, nobody is tainted. According to you, nobody is tainted.
Well, I am representing that 19,000.
Oh, where do you stand? I mean,
I say on a point of law, when this honorable court directed that you have to decide admissibility.
but according to you, is the entire process without taint, or there are people with
No, there are, I would say, tainted persons. Who are those tainted? Who have been given appointment after expiry of the panel, number one.
Yes.
Anybody who was given appointment after expiry of the panel, of course, this is illegal, and that can easily be found out from the very date itself, and they should go.
Then,
My lord, if there is,
apart from this category,
my lord, if there is any candidate who even without participating has got the appointment, must go. It's illegal.
yes.
All I say, my lord, the parameters of illegality, lordships definitely apply. But if your lordships apply the parameters of illegality after observing or finding that there is a sacrosanct electronic records, that is absolutely right. And therefore, what is the wrongs has to be found out after seeing what is the mismatch from this one. That is only permissible once that electronic records are found to be correct under 65B. But on the face of it, tomorrow somebody else gives a certificate. This would be, my lord, allowing an amendment to the 65B itself. And to that effect, my lord, the only submissions by the counsel of the CBI was one paragraph in his entire judgment, paragraph 29. We have submitted our charge sheet, matter is pending. That's all. There was no answer to my very fundamental point that this is so important, can take, nice up. Why didn't you say so at the first time? Why didn't you say so in the second time? And why you are saying at the last time? But I have a probable answer. They knew that 65B certificate signed by someone, some MD electronics, that is legally, that has got no value, zero value. That's the reason in November 23, they did not show it before this honorable court. That's the reason in the first report, they did not annex it. Only in the second report, they annexed it. And in the last report, my lord, a new story of the scan take came, which I said that there they are referring to .dat format, which is a processed. But today, I am also representing visually challenged candidates. about 100, though only one person has signed and is before your lordship, they have also lost a job because of this judgment. My lord, my respectful submission before your lordship would be that the criminal case is pending. Ultimately, it would be decided who has done what and he must be punished. Prior to that, in a writ proceedings, whoever has jumped the panel, they should also go. But other than basing that this is the CBI record so sacrosanct may not be a proper interpretations of.
Thank you.
These are my responses.
Yes, Mr. Who's now going to argue? Maybe the next counsel under the. Mr. Rohitgi is here.
I am there.
All right. Now we have Mr. Madiyal, right? With
I
Mr.
just take
Rohitgi.
3-4 minutes. I'll not take more than that. Much of what I
1 second, we'll go. No. We'll go by the rules. So we'll go by what we have got the record now. No interventions. Yes.
Because I appear in item 17.2, 10.5, 17 and 18.
All right. What do you have to say?